All right. Good morning, everybody. It is great to see you. Congratulations for being here on a Monday. My name is Ellen Zwarnstein. I'm the Executive Director at the Michigan Center for Civic Education. And your judges are now here, so they will introduce themselves. They will ask you to introduce yourselves, followed by the reading of the question. And you'll see time cards in this particular window, hopefully at the right time, to indicate how you're where you're at in terms of the hearing. So without further ado, your judges are here. Wish you the very best for your hearing.
Thank you.
We're so glad to see you. Congratulations for being in the national finals. Top 12, I believe it is today. My name's Rita McCannon. I'm an attorney in Huntsville, Alabama, and these are your other two judges.
Hi, everyone. I am Tom Vance. I'm a professor of education at Kansas State University. Looking forward to a great conversation.
Yes, my name is Darcy Kern. I am a professor of history at Southern Connecticut State University, also an alumna of the program. So I've been where you are, and we're looking forward to hearing from you.
How about introducing yourselves to us?
Hello, my name is James Driscoll, and I am a two-time speech and debate national qualifier, and I'm also my high school's graduation speaker.
Hello, my name is Laura Castro, and I'm a member of the Mayor's Youth Committee.
Hi, my name is Tessa Jagoda, and I'm a team officer on my school's Model United Nations team, and our coaches are Miss Lindblom and Miss Litzenberger.
Be talking about Unit 3, Question 1, and I'll read it, and then we'll look forward to hearing what you have to say. Quoting Oliver Wendell Holmes, "I don't think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we couldn't make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review?" We look forward to hearing from you.
A balance is made of three fundamental parts: the left scale, the right scale, and the vertical post in the middle. A court is similar to a scale, wherein each party competes to tip the scales of justice in its favor, while the judge represents the neutral post in the middle.
So when the Supreme Court has used judicial review to expand federal supremacy, it has tipped the scale of sovereignty away from the states. In doing so, the court has created an imbalance of power, overstepping its constitutional authority and its role as the neutral post. Therefore, Congress must recalibrate the scale.
Article 3 does not explicitly grant the power of judicial review, yet Federalist 78 implies that the court has the power to ensure Congress does not violate the Constitution. 1803 Marbury v. Madison solidified judicial review to decide the constitutionality of federal laws and strike down acts of Congress.
While the court did not strike down another federal law until 1857 Dred Scott v. Sanford, it did strike down state laws, beginning with 1810 Fletcher v. Peck. 1816 Martin v. Hunter's Lacey expanded judicial review to state court decisions, and 1821 Cohens v. Virginia applied federal jurisdiction to review state criminal proceedings. Thus, the scales tipped towards the supremacy of the federal judiciary.
And as states have infringed upon individual liberties, the court has used the 14th Amendment's due process and equal protection incorporation to limit the scope of state legislative powers.
Consider 1958 Cooper v. Aaron, which invalidated actions of the Arkansas legislature, which undermined 1954 Brown v. Board of Education's equal protection ruling. The Cooper decision broadened judicial review to all state actions, placing supremacy in federal judicial interpretations.
And since the federal judiciary can overturn legislation passed by popularly elected officials, judicial review is a counter-majoritarian practice. The founders intentionally created an independent judiciary removed from the influence of the popular majority, free to make fair decisions based solely on constitutionality and federal statutes.
Article 3, Section 1 grants federal judges lifetime tenure, and Article 2, Section 2 grants the president judicial appointments with the advice and consent of the Senate. Federalist 78 asserts an independent judiciary is peculiarly essential to a limited constitution because it secures individual liberties without bending the Constitution to popular will.
To exemplify, 1942 Skinner v. Oklahoma struck down Oklahoma's Habitual Criminal Sterilization Act because it violated the equal protection and due process clauses. So yes, the Supreme Court is counter-majoritarian and its independence remains essential in upholding the rights of the people.
But since substantive due process has enabled the court to broaden its constitutional interpretation and to exercise near legislative powers, Congress ought to have an override of judicial review. 1905 Lochner v. New York overrode state labor regulations, formally establishing the freedom of contract. However, Justice Holmes's dissent explains that the Constitution does not advance an economic theory and that individual labor regulation should be left to the state legislatures.
This is an example of judicial activism in which the court decided public policy, a legislative power, not a judicial one. Similarly, 2010 Citizens United v. FEC controversially defined corporations as people and shifted the scope of the First Amendment to include campaign financing.
So Congress should be able to override judicial review decisions made by the court with a 2/3 majority of both houses. However, this override should not extend to suspect classification cases to protect the rights of minorities, nor should it extend to provisions which the Constitution plainly prohibits in order to retain the intention of the Constitution. In this way, the legislative override would only apply to judicial activism decisions. And because it's difficult to overturn court decisions either by constitutional amendment or by Supreme Court reversal, it becomes increasingly important to check the court.
An impartial third party, a neutral post, is an important factor in ensuring balanced judicial decisions. Thus, the Supreme Court cannot act independent of its intended role as a mediator. It must ensure objectivity for the scales of justice to endure.
Thank you. Let me ask you, would you all propose any change in either the judicial nomination or the judicial confirmation process? Explain your response.
Yes, I would change the lifetime tenure and I would make a term limit for the court judges. And this doesn't have to be a finite term limit. It can be in sections. So we can have a term limit of, say, 6 years, as in the Arizona Constitution, where judges would be reappointed by the president. And so in that way, we can assure that judges are held accountable.
You can go, Laura.
Okay, I disagree with Tessa because here in Arizona, we have the governor appoints the judges here in Arizona and the people continue to keep those people in office, but it incorporates Federalist 10 in special interest groups influencing our government, where corporations are influencing these campaigns through millions of dollars, which politicizes our court and undermines the independence of the court.
I would get rid of the nuclear option that the Senate has used in order to decrease the threshold of judicial appointments. And this is important because the advice and consent of the Senate and large support for judicial appointments is essential for the legitimacy of the court. Because when we have all Democrats voting against the appointment of Amy Coney Barrett, that becomes especially pernicious when the court has to be independent, when it has to have the support from the Senate. So getting rid of the nuclear option would be essential to reinstating the legitimacy of the court, especially in public opinion.
To follow up quickly, so what do you suggest? You like what you don't like the Democrats voting against her? What do you suggest as a solution?
Well, getting rid of the nuclear option is a start. So judicial appointments should not be a simple majority. And I think that getting rid of the nuclear option would force both sides of the aisle to work together, because the nuclear option has created animosities between the party within appointments in the federal judiciary. And before we had the nuclear option, we could appoint Supreme Court justices without large dissent.
You mentioned that you talked about judicial activism and that Congress should look at judicial review with a 2/3 majority. How do we determine, or how does Congress determine what is judicial activism?
Well, judicial activism can be seen when the court makes a decision and you can look at their opinions and where they have their reasoning. For example, in 2010 Citizens United v. FEC, they used the First Amendment to consider corporations as people, which is clearly an activist decision on the court. And in that way, the Congress can determine to classify that as judicial activism and then practice that override.
And in activist decisions, the Supreme Court's opinions often make clear that they are making nearly an activist provision. For example, Griswold v. Connecticut or Roe v. Wade cited the penumbras of the articles. They didn't point to any one article in specific, and in fact, they conceded that there was no right to get an abortion or even to to have same-sex marriage within Obergefell v. Hodges, but they used the application knowingly under the penumbra theory in order to advance a judicially activist decision. So the legislature and Supreme Court definitively knows when something is judicially activist.
But haven't there been a number of court cases that could be considered judicial activism that have done some really positive things for our country? And so where should we draw the line? How should the court, in deciding the balance of power between the division of power between the national government and the state governments, what principles should guide the court in terms of deciding in favor of the national government's power or the power of the states?
I would say definitely the court should exercise judicial modesty, in which they only interpret the Constitution and when it is in direct conflict with a constitutional provision. So although that judicial activism can be seen as an issue if it inherently violates the Constitution and this inherently leads the court to make a judicial activist decision, then that's justifiable because it is the court's duty to interpret the Constitution if there are any violations of it. So in that way, it would be beneficial for judicial activism to be only if applied through actual constitutional infringement.
Quick follow-up, is the incorporation doctrine an example of judicial activism by the Supreme Court?
No, it's not. I would advance the privileges and immunities clauses, which was the intent of the 14th Amendment, to apply the Bill of Rights to the states, such that every single citizen is entitled to the privileges and immunities of the 14th Amendment. Unfortunately, the Slaughterhouse cases actually gutted the privileges and immunities clause, but the spirit of that clause lives through the equal protection and due process clauses by which the Supreme Court incorporates rights to the states. So it's not judicially activist in that the intent of the 14th Amendment, a constitutional provision, was to incorporate the Bill of Rights to the states.
Thank you.
Let me ask you, when we have a seat vacant, whether it be by the death of a justice or the retirement of a justice, can the appointment of a new justice change history?
Yes, the appointment of a justice can definitely change the history of our nation. For example, with the death of Ruth Bader Ginsburg, she was then replaced with Amy Coney Barrett, which is a more conservative justice. And with the Supreme Court being a majority being a 5-4, the court has now easily swayed with a conservative majority and can now sway future decisions for a more conservative approach.
And this has the potential, the nomination or the appointment of Amy Coney Barrett has the potential to change history because there was mass controversy surrounding the Roe v. Wade decision and whether or not she would be able to overturn it now that the court had a conservative majority. So in that way, because of Ruth Bader Ginsburg's death and Amy Coney Barrett's nomination, we can see how the Roe v. Wade could potentially be overturned and infringe on the liberties of women across the nation.
And since we're talking about Ruth Bader Ginsburg, she was, I would say, one of the most influential Supreme Court nominees to be seated on the bench because she had a long-standing history of fighting for women's rights. And she actually had a quote that she used to say that representation for women will not be enough in America unless all 9 justices are seated on the bench and unless all 9 justices are women. So in that case, Ruth Bader Ginsburg knew that when we seat representation on the bench for gender and for race, that creates a more inclusive America.
Well, but to that point, doesn't that make a simple assumption that all women believe the same way or all people of one race believe the same way?
You make an excellent point, and that would be considered tokenism. And to argue James' point, in the Loving v. Virginia decision, it was decided in 1967. And so that Supreme Court was majority men, and the Supreme Court decision was a 9-0 decision. And so it doesn't have to be representative of the people, but necessarily the justices are independent in deciding the decisions by the Constitution. And it doesn't matter if they're representative or not, because their decisions are in common with the Constitution.
And we have to remember that we live in a dynamic society, and although one like race or gender cannot ultimately represent the entirety, it's essential that we have at least some sort of representation in our courts and in our government system for those minorities, even though it may not reach the scope of every different group.
Real quick, was National Judicial Review as a check on Congress or the president, a co-equal branch, was that power originally intended by the founders? Why or why not?
Well, judicial review already existed previous to Marbury v. Madison, and it was exercised by England with the British colonies by the Judicial Committee of Privy Council, where they null and voided over 600 acts out of 8,000.
And the Federalists at the Constitutional Convention, there was actually a lot of debate on the role of judicial review, so that founders knew well in advance that judicial review would be a judicial power.
Thank you very much.
Mhm.
It was interesting. I appreciated all the good answers, and I appreciated you being quick on your feet when I asked you some things that didn't have anything to do with maybe what you had previously spoken about. Judges, you want to give some feedback as well?
Sure. I thought that was interesting. You guys did a very different presentation than what we've seen so far. And I really liked your emphasis on judicial modesty. I think it's a lost art among politicians and really highly educated people. I liked your reference to the scale as sort of an analogy that you kept coming back to. That's a very common law analogy. So I thought that was good. I liked how you used local references. You talked about Arizona quite a bit, and I think it's great that you know your state and the judicial process in your state. Laura, I thought your answer to my question on Loving v. Virginia and how that was decided by all men, I thought that was a great response to my question. This was very thought-provoking, and I really enjoyed listening to you guys.
Thank you.
I concur with all of that. It was a really fine performance. You can, the prepared remarks are always good on the last day, but I thought yours were in particular good and well reasoned, and you brought up things, quite frankly, that we had kind of forecasted to ask about in your response. I would have loved to have dug in a little bit more about this legislative check and how that might fit into the whole idea of a counter-majoritarian force. You did, by the way, you did the requisite sort of, but still there are, the rights of minorities don't count. They can't be reviewed. And so I would have liked to have explored that further, but that's just the sign of a really great group when you get to the end and there are still some loose ends that you'd like to tie up. And so I thought you did an excellent job.
We'd like to tie them up too.
I think the sign of a good group, if I have 30 more seconds and don't get signed out, I think the sign of a good group is somebody that we'd really like to go to McDonald's and eat with. And I think that y'all are that. I think we would love to take our break and go with you and ask you some more stuff or get you to tell us a little more about where you're coming from. But I too, you about took my breath away saying, men made that decision. That was sharp. That was sharp. I'm not sure I'd go with you about leaving them all men on the court, but I thought it was a great answer. Thank you all very much today, and good luck the rest of the way.